Good morning, afternoon, evening to everyone. Welcome to our ICANN 62 update webinar. My name is Alex Chilikov and I'm a research analyst at Validex. I'll also be your moderator. The duration of this webinar will be around 30 minutes and we'll cover the discussed during the last ICANN meeting that took place in Panama between the 25th and 28th of June. Just to clarify, the duration of this webinar will be 30 minutes and not 60 as the invite specified. The first speaker today is going to be Ashley Roberts, who is a senior manager at Validex. He's going to discuss WHOIS in the light of GDPR and the proposed Expedited Policy Development Process, from now on referred to as ePDP. He's going to be followed by Jeff Newman, our Senior Vice President for North America, who is going to give you an update of the new gTLD Subsequent Procedures Policy Development Process and the future of gTLDs. Before we begin, if you have any questions and or comments, please submit them through the question panel, which you should be able to see on your screen. If time permits, we'll try to answer your questions at the end of the webinar. If we cannot cover all queries now, we will provide you with a response by email after the webinar. If you encounter any technical issues, please send an email to info@validex.com. This mailbox will be monitored during the course of the entire webinar. After this brief introduction, it's time to give the floor to Ashley Roberts to talk to you about GDPR, WHOIS, and the ePDP. Ashley.
Thanks very much, Alex. All of you are aware of the GDPR, and probably most of you will be aware that it's had an effect on the WHOIS system. So I just wanted to start by providing you with a bit of background as to why and how GDPR affects the WHOIS. So registries and registrars, who I'm going to refer to collectively as contracted parties, as part of their contracts with ICANN, they're required to publish WHOIS information for all gTLD domain names. Now, in many cases, that WHOIS information is going to contain personally identifiable information of individuals. And since GDPR is about protecting data privacy, it brings it into conflict with those ICANN contractual requirements. Therefore, ICANN have been working on a way to try and resolve this conflict between the requirements of the ICANN contracts and the GDPR in a way which will allow contracted parties to comply with the law. So what are some of the different perspectives within ICANN on this topic? Due to the large fines that are possible for non-compliance with the GDPR, a lot of contracted parties are taking quite a cautious approach and preferring to redact all registrant information from the WHOIS unless the registrant has provided consent for the publication. Now, on the other side, you have many users of WHOIS, including those involved in brand protection, online security, and law enforcement, who want to maintain as much access to full WHOIS data as far as possible. And then in a third bucket, you have data privacy campaigners who, unsurprisingly, are pushing a conservative reading of the GDPR. So you may have heard this term, the temporary specification, but what actually is it? Well, it's ICANN's attempt to address, try and get some kind of compromise between these competing interests and address this issue of GDPR in the WHOIS. So the temporary specification itself, or also known as the temp spec, is actually an addendum to the contracts of registries and registrars, which came into effect on the 25th of May, so the same date as the GDPR came into effect. This temp spec through emergency powers of the ICANN. What the temp spec actually does is loosen some of the requirements upon contracted parties for publishing WHOIS information. It permits the contracted parties to redact a large amount of the information they were previously publishing in the WHOIS, including the email address, the name of the registrant, and the contact address of the registrant. And importantly, it doesn't discriminate between whether the registrant is based in the EU or not. As many of you will have seen, this has meant that the majority of WHOIS records for gTLD domains are no longer providing much useful information since the 25th of May. It is important to note, though, that although a huge amount of WHOIS information has now been redacted, there is a provision within the temp spec which requires contracted parties to provide the full redacted data to third parties that request it if they have, if it's determined that they have a legitimate interest to the data in line with the GDPR. So you mentioned ePDP recently. What actually is it, and what is the work that it's trying to do? So I mentioned already that the temp spec was passed by emergency powers of the ICANN board. To try and, as a kind of counterbalance to the fact that it was passed through emergency powers, the temp spec has a limited time of 12 months. So after that 12-month time frame, it cannot be extended beyond that. So therefore, to try and have something permanent in place beyond that point, something known as a consensus policy has to be created. And the process for creating a consensus policy within ICANN is through the Policy Development Process, or PDP. An issue historically has been that PDPs can take quite a bit of time to complete their work and come up with recommendations. It's not unusual to see a PDP take 2 or perhaps even 3 years to get through all of their work. Since with this particular case we're constrained by a 12-month time frame, the GNSO decided to use an alternate mechanism which they haven't used before, a kind of alternate version of the PDP known as or PDP. Now, if we can briefly skip to the next slide, there's a timeline, a draft timeline, which shows how the GNSO are intending the work of the ePDP to go. Now you'll see that although there is an overall 12-month time frame, they've had to build in for things such as public comment period, a review of the public comments, and then approval of the recommendations from the various authorities within ICANN. So the actual amount of time that the GNSO have to do the work and come up with the recommendations is only about 3 to 4 months. That's seen by the kind of orange block at the top of the timeline between ICANN 62 and ICANN 63. So the intention at the moment is that this ePDP working group will have their initial recommendations by the time of the next ICANN. So going back to the previous slide, the groundwork for the ePDP was started recently at ICANN 62 in Panama. The focus for the GNSO at that meeting was on drafting for the work for the ePDP, which is going to set out the ground rules for the working group, the guidelines for how it's going to operate, and the composition of the working group. Now, the actual drafting of that charter is being done by the GNSO Council. It's a little more complicated than it might normally be for a standard PDP. And one of the main reasons for that is because a standard PDP is open to all. Anyone can join it. There's no limits on who can join or how many people can join. But the GNSO took the decision that because of the short time frame to complete this work, they wanted to limit the numbers of people that could join this working group to try and increase the efficiency of the work. But that in turn has then caused a problem of trying to agree on division of representatives within the working group from the different interest groups at ICANN. So there was a lot of discussions within the GNSO Council on this topic in Panama. They were not able to agree on a solution at Panama, but there's been ongoing discussions since, both on face-to-face meetings and on the mailing list. As of this morning, they seem to be close to a solution for the composition of the group. It looks like it's going to comprise of about 36 members, but this is yet to be formally agreed. The other main contentious issue in relation to the drafting of the charter is what is the scope of the ePDP going to cover? On the one side, you have the contracted parties and non-commercial interests who want the scope to be quite narrow and only focus on what is in the current temp spec, so namely the publication and collection of WHOIS information. And the key question for them is whether to essentially just reaffirm what's in the temp spec as a permanent consensus policy, or whether anything needs to be changed in that. Now, on the other side, you have the commercial stakeholder group, so that's business and intellectual property interests, who want to have a slightly wider scope of the ePDP and include the question of access to redacted WHOIS information, and allow the working group to try a streamlined method for third-party information. Now, that's been an ongoing discussion as well since the start of Panama, and this has been a slightly more contentious subject, with both sides quite entrenched in their positions. They've yet to really bridge that gap, but nonetheless, they've set a target of the 19th of July to agree on that and all of the other language in the Charter, and actually formally approve the Charter. And so finally, I just want to look at, from your perspective, why is this ePDP important? Why is it something you should be following? So from the perspective of the contracted parties, they're concerned with making sure they comply with the law. So whatever comes out of this ePDP is going to tell them what can be amended in their ICANN contracts in terms of what they have to do in terms of WHOIS. So the contracted parties' interest is that whatever comes out of the ePDP is not asking them to do anything with WHOIS to break the law, i.e. the GDPR. Now, from the brand owner perspective, the key thing with GDPR, it has changed, is that public access to WHOIS is now extremely limited. You'll be aware that the WHOIS performs a lot of useful functions in terms of brand protection. So being able to identify a domain owner for the purpose of filing a UDRP. If you don't know who owns the domain, then it can make it a lot more difficult to actually construct a case against an infringer and identify any kind of pattern of behavior. If you're interested in perhaps looking into purchasing a domain from a third party, if you're not able to identify who actually owns that party, it can make your strategy that much more difficult. Knowing whether they're a professional domain investor or some other third party infringer. Also, some of you may have been involved with trying to perform an audit on the domain portfolio of your company. If you can't see who owns it, there might be a domain name that contains your trademark, but if you can't establish who actually owns that domain, you might not know whether it's already belongs to your company or is owned by some unaffiliated third party. And related to that, many of you will rely on reverse WHOIS services to help you in establishing patterns of behaviours against infringers. These reverse WHOIS services are going to be massively affected by these new regulations, and depending on what comes out of this ePDP, the reverse WHOIS services may not be able to continue. So all of these important uses of WHOIS is important, why the question of scope in this ePDP is such an important one. There are arguments on both sides as to whether the question of access to WHOIS data should be included in the scope of this ePDP. From one perspective, you can say that if the question of access is not included, then it's just going to be deferred to a later date, and it just prolongs the problem that you have with not being able to access WHOIS data. However, on the other hand, if you do include it in the scope, then it just increases the amount of work that has to be done in an already optimistic timeline for the ePDP. And one might argue that it's just setting it up to fail from the start. If the ePDP were to fail to reach a solution by the 12-month deadline, then the temporary specification, and it could potentially be a worse position, because without temporary specification and without a permanent solution to take its place, then you'd be left without any right to access redacted WHOIS data other than through a court order. So yeah, it's definitely an important question as to whether the question of access is included in the scope. Needless to say, we're going to be continuing to follow the progress of the ePDP. Things are going to be changing very quickly on a daily or weekly basis, but we'll make sure we're providing our clients with regular updates. And that's the end of my bit. So I'm going to hand over to Jeff now, who's going to talk you through the recent updates with the Subsequent Procedures PDP.
Thanks, Ashley. This is Jeff Newman. I'm happy to talk to you all this morning or this afternoon, depending, evening, wherever you are, on another issue that made progress during the ICANN 62 Panama meeting. Although GDPR, the topic that dominated at ICANN 62, I believe some good amount of progress was made on what we call subsequent procedures, or as others refer to it, as work on the next round of new generic top-level domains. So on this slide here in front of you, there is a timeline of where we are currently in the process, on the policy development process for work on the next round. You'll see that at ICANN 62, which is represented by the green June 2018 bubble, we discussed the final draft of the initial report, which has since, as of July 3rd, come out and been published for public comment. And there's a link on the slides that we're going to send out after. We'll send a copy of these slides out after so that you can actually get to the initial report. The initial report is it's about 300 pages long, so it certainly is a culmination of hundreds of hours of conference calls, thousands of emails, and the work of near, or actually over 200 people that were working on all of the issues involved for the next round of new gTLDs. The public comment period will extend until approximately early September 2018, and at that point the comments will be summarized and analyzed, and then the working group will begin work on a final report, which it hopes to complete by the end of the first quarter of 2019. The subsequent procedures, this particular report only addresses what we call work tracks 1 through 4, which encompass most of the issues involved for the next round of new gTLDs, except for issues involving the use of geographic names at the top level. So if we go to the next slide, geographic names at the top level are addressed in what we call work track number 5. Work track 5 got its start a little bit later than the other work tracks. So consequently, the report on work track 5, the initial report, is likely to come out later than, obviously later than the initial report for the 4. It's hopefully going to come out in September of this year. So work track 5 again deals with geographic names at the top level, and really the issue that has been taking the longest on this particular topic has been, how do we make the process of awarding generic top-level domains that may match geographic names? How do we do that in a predictable manner, and one in which avoids confusion with the geographic connotations of those same terms? And as you can imagine, as it was in the 2012 round, certainly this issue has gotten the attention of the governments in the Governmental Advisory Committee, but also it has gotten a lot of attention from members of the ICANN board, and as well as the Generic Name Supporting Organization. This work track alone has more than 150 participants, and so if you are in this work track and listening to this, you certainly know the volumes of emails that have gone back and forth in discussions. The hope is at some point to join this work track with the other work tracks, probably around the time of the first quarter in 2019, but if not, likely a final report could come out as late as the second quarter of 2019. We want to go to the next slide. So what happens next? And this is just a kind of best guess or best case scenario if we were to play this timeline out and the final reports get to the council, the GNSO Council, by the second quarter of 2019, at that point, just as with any policy development process, it would have to be adopted by the GNSO Council and would then have to go to the ICANN board. The ICANN board does have to have a public comment period on the final recommendations, and then would have to approve those final recommendations, at which point what we call implementation would begin. Assuming that it would take about a year to do the full implementation, that would lead us into the third quarter of 2020, and then final guidebook, AGB stands for Applicant Guidebook, then at some point submitting applications in mid to late 2021. So it's difficult to predict with any kind of certainty when all of this will happen. Things could move a little bit faster, things could move slower. It really all depends on the comments that we received to the initial report, but also on any issues that likely would emerge between now and when that implementation begins. So if we go to the next slide, as I said before, the initial report for new gTLDs, subsequent procedures, has come out. It came out on July 3rd, and the public comment period ends on September 5th. There are a number of topics in there where the initial report asks for feedback. In some cases, the initial report provides some preliminary recommendations, but in all cases, it provides key topics for feedback that the working group wants to hear back input from the community. So some of those key issues include the future treatment of .brand registry. So this covers issues such as .brands have their own round, either prior to or after the introduction of rounds for other types of top-level domains. It also includes questions about should a contract for .brand registries look any different than contracts for other types of registries. The second topic is the future treatment of what's up here is called GAC advice or government advice. So in the 2012 round, if the government's provided consensus advice, what that meant is that the ICANN board could, created a presumption that the string for which the GAC provided advice would not proceed. Now, some of the community have argued that because the ICANN bylaws have changed between the 2012 round and now, where the board may only reject GAC advice with a vote of over 60% of the board, that perhaps that presumption against the string being delegated may not be necessary. A third area is what's called registry service provider pre-approval process. So especially for brands and other top-level domains that a string or a top-level TLD in the 2012 round, while they certainly knew what they wanted to use the top-level domain for, they knew that they couldn't provide the services themselves. And so they went out and sought the services of an established registry service provider, whether that was a VeriSign, Affiliates, Newstar, Nominet, or others out there. They went out and sought their services. But really, when a brand was applying for these or any other TLD, they never knew whether those service providers or any other new service providers would pass ICANN's requirements to become a registry for the new top-level domains. Because of that, because of the uncertainty as to whether providers would pass the testing process, many in the working group decided that they would like to try the concept, introducing a concept of having a pre-approval process whereby before the actual round begins to select strings for new generic top-level domains, that there could be a process to pre-approve back so that when it came time to apply for a string, let's say a brand could then look at the list of pre-approved registries and choose one of those, and then not have to answer all the technical questions in the application process. Or if it chose, it could apply itself to become a registry, either through that pre-approval process or when the selection process begins for new strings. So there's a number of questions around that process. There's also issues around what's called closed generics or exclusive use top-level domains. So although not in the applicant guidebook for the 2012 round, ultimately the ICANN board did not allow applicants that applied for generic terms to go forward if that string was reserved for that entity or any of its affiliates. In other words, if a registry wanted a generic string, it basically had to follow the traditional model of offering third or second level registrations to third parties. This was something that was very controversial during the 2012 round. You were a number of competitors of companies that applied for closed generics had argued to the ICANN board that to do so would restrict competition, while those applicants that applied for those terms said that they could provide better services to end users by using generic terms such as .music or .books or other generic terms for the benefit of end users. And so there are a number of questions about these types of top-level domains. A couple other issues, just to quickly go through those. In the 2012 round, there was a priority was given to top-level domains that applied as communities if those communities met certain requirements. Those requirements were extremely stringent during the 2012 round. So there are questions here as to whether those are the right questions to ask, whether the criteria was appropriate for community top-level domains, whether the evaluation process was done correctly, and whether the ultimate question of whether communities should continue to have priority over other types of top-level domains. Another issue that raised comments during this process was the use of plurals versus domains. And in fact, in this past 2012 round, ICANN did allow plurals and singulars of the same string to go forward. And so we now have registries for things like auto and autos, plural, photo and photos, accountant, accountants, cruise and cruises, all that coexist. While many of the plurals and singulars were ultimately bought by the same entity because they recognized that there could be confusion, a number of plurals and singulars are not owned by the same entity, and accountant and accountants are just one example. Now, we haven't seen too many of those in the marketplace, but you can imagine if one of those were to take off and become popular, especially if, let's say, accountant has verification requirements, but the plural version of accountants, does not have the same type of verification requirements. You could see how something like that causes confusion in the marketplace. So therefore, there is a recommendation from the members of the working group to not allow plurals and singulars of the same strings go forward. And a comment is invited on that issue. And another issue, last issue we have on the slide is something called name collision, which was certainly something that caused a lot of controversy in the last round, which was what do we do in situations where a new string that's applied for has been used in the past by another entity for internal networking purposes, and what happens with the collision results or when collision does result. And there are studies underway now as to what issues were caused and how those could be prevented in the future. These are just a few of the dozens of issues that are raised in this initial report, and the comment period does end on September 5th. We hope to have a future webinar on specifically the initial report and what comments we think a .brand should make if they want to make some comments during this initial report period, but that should be in a few weeks from now, so please look out for that. And although these are just two of the many issues that were discussed at ICANN 62, these are the ones that we wanted to provide you all with the highlights from that session.
Thank you very much, Jeff. Due to time limitations, we might have to go over only one or two questions. So the first question we have is related to GDPR, and I believe Ashley will be best equipped to answer this question. So the question is, how does the GDPR affect the UDRP? How do I make a UDRP filing if I can't see the owner of the domain? Ashley, on to you.
Thanks for that, Alex. Yeah, it's a really good question. So there's a couple of things that you could look at trying. I mean, it's definitely a problem, but there are a few things you can look at. Firstly, although the email address of the domain is now redacted, the method for WHOIS users to attempt to contact the registrant. So registrars are required to provide either an anonymized email address in the WHOIS that you can feed your inquiry through to, or a web form that you can type an inquiry into, and that is then redirected to the registrant. So there is a way to approach the registrant in order to try and get some information out of them. It may well be, depending on the circumstances of the particular case, that you don't want to approach the registrant, or you might approach the registrant and you just don't get any kind of helpful reply. So if that fails, then I mentioned in my presentation that there's a provision in the temp spec which requires contracted parties to provide the redacted WHOIS information to third parties that request it if they can demonstrate a legitimate use for the data. So you can find out who the registrar of record is for the domain name in concern. You can approach that registrar and request the WHOIS information for the domain name. Unfortunately, what provision in the temp spec doesn't do is any kind of criteria that the registrar has to abide by in terms of determining in which cases they should provide that WHOIS information. So what that basically means is that it's up to the registrar themselves to determine whether your request meets the standard of legitimate use under the GDPR. So you can certainly approach the registrar for the data, but there's no guarantee that they will provide it to you. So if you don't have any luck with that, then what you can do is you can try and put your case together for your UDRP filing. You can file it with the UDRP provider as a DOE action, and then the UDRP provider themselves can get the registrant information from the registrar and provide that to you. Now, there could be additional complications from filing a UDRP action before you actually know who the holder of the domain name is. So you might have filed your action, you then get the WHOIS information, the registrant information from the DRS provider, that perhaps it's actually a domain that belongs to your company. WIPO have said in such cases that they would refund the UDRP filing fees. I'm not quite sure what the position is of some of the other UDRP providers. An additional complication with using that approach is that you won't, if you don't know the identity of the registrant before you make your filing, then you're not going to have been, or it's certainly going to be a lot harder to have established any kind of pattern of infringing behavior that you might have been able to put in your case. So although these are kind of approaches you can try, they're definitely not perfect solutions for you.
Thank you very much, Ashley. And one question on subsequent procedures. This will be answered by Jeff. The question is, the initial report contains some recommendations, but also a lot of questions on which are seeking feedback. Does this mean there will be a second public comment period?
Yes, thank you for the question. So there are, as the question asks, there are a number of areas in the report that that the working group could go down depending on the public comment, or even depending on the public comment, an option can be pursued that wasn't presented. And because of that, as well as a recognition that there are certain topics that may not have been addressed as adequately as we wanted to, things like the use of private auctions or even the use of public auctions for last resort as a result of contention sets, there could be additional supplemental reports that do come out between now and the end of the year or early next year, depending on the progress made by the working group. So while at this point we can't definitively say whether there will or will not be supplemental reports, if the working group determines that there are solutions or proposed recommendations that it would like to put forward that were not adequately addressed or presented in the initial report, then certainly there could be a supplemental report or multiple supplemental reports that are issued. But that does not mean, however, that there will necessarily be a complete second full draft of this initial report out for public comment. So I guess the answer is it'll depend, but based on the fact that there are some issues that have not been presented, it's something that the working group is looking into at this point.
Thank you very much, Jeff. And thank you everyone for joining. You should receive a recording of the webinar within 24 hours. If you do not, please send an email to info@validate.com. Thank you for your time and enjoy the rest of your day.